Uh, First of all, I want to welcome you to this public hearing on the proposed rules for mold assessors and remediators here at TDLR. It's about 1:02 p.m. Thank you for your interest and your participation here today. We really need your input and appreciate your comments on this rulemaking process that we're going through. Before we get started, I'd like to just introduce the staff that's up here. I'm Brad Bowman. I'm the General Counsel here at TDLR.
I'm Laura Pefferly. I'm Assistant General Counsel.
I'm Pauline Easley, the Rules Coordinator for this program.
I'm Nita Lomison, and not the Rules Coordinator for this program, sitting in.
Right, then we have some other staff in the room as well that you may get to know. So the purpose of the hearing today is to hear from you about any interested person about your comments on these proposed rules. And so we're going through a rulemaking process right now, and the background on that, as you may know, in the last legislative session there was a bill, Senate Bill 202, that transferred 13 regulatory programs from the Department of State Health Services over to TDLR in 2 phases. And we've already gone through one phase. There were 7 programs in that first phase, and that happened last October. And this program is part of the second phase of programs that are transferring. And the target date for that transfer is November 1st. Of this year. And I do want to clarify that as we speak right now, this program is still being regulated at the Department of State Health Services. So the rules that we're going to be looking at here today, those would be the rules that would take effect once TDLR takes over that program on November 1st. So we published these proposed rules in the Texas Register and put them out on our website for public comment. That public comment period is still ongoing, and that ends on May 22nd. So if you want to, you can make a comment here today with your testimony, and that will be a comment that we'll consider as part of the rulemaking process, or you can submit comments in writing to us. And there's instructions on our website on how to do that, and I'll just give you the email address that you can use for that, and also anyone listening online. It's erule.comments@tdlr.texas.gov. Okay, and so we have on the table over here, we have copies of the proposed rules. We have an agenda, and also there's a sign-in sheet if you don't mind signing in. And if you want to make a comment here today, if you'd please fill out one of the witness comment forms and turn those in to Pauline or to me. So just kind of cover some kind of ground rules for the hearing today. So the purpose of the hearing is to hear from you. We'll give you some overview of the rules, but primarily we're here to hear your comments and what you have to tell us and input you have for us on these proposed rules. We're probably not going to try to answer any in-depth or really substantive questions about the rules because, again, we want to hear your thoughts and your input on the rules. Try to limit your comments to about 5 minutes, and if you can, just so everyone gets a chance to speak. And we are recording the hearing, and it's also being broadcast over the internet through our website. All right, I'm going to turn it over to Laura to kind of give you an overview of the rulemaking process that we're going through, and also the rules themselves, some highlights of the rules.
Good afternoon. Again, I'm Laura Pefferly, and I'm the Assistant General Counsel. I was on the attorney on the Mold Assessors and Remediators program at DSHS until 2 years ago, and I'll be the attorney for this program here. just to kind of give you an overview of the rulemaking process, I'm going to do that first, and then I will go over the proposed rules briefly before the comment period, before the comment session. So today's hearing is another opportunity for you to provide comments to us on the proposed rules. No decisions are going to be made today. After the hearing today, the department will consider all of the comments that are received, both the oral comments today, written comments that you submit today, written comments you submit before the end of the comment period. The changes may be made to the rules based on the comments. You may see changes at adoption that aren't there now. There may be some editorial corrections. The department is going to be responding to all the comments received during the comment period, whether a change is made or not based on them. And the responses will be published in the rule adoption preamble, and there will be an explanation of why or why not the change was made. After the department staff have considered the comments and made the changes, the proposed rules go to our commission, and they consider them, and then they vote whether to adopt them or not. The commission will consider all of the comments received during the comment period, and the staff's recommendations on how to respond to those comments and what changes to make. There will be another opportunity to comment at that commission meeting when the decision is made whether to adopt them or not, but at that point those comments wouldn't be able to be considered for the adoption because the rules are final at that point and either going to be adopted or not. So if you want your comments addressed in the adoption, you need to make them before the end of the comment period to see that written response in the preamble. The mold assessors and remediators proposed rules are scheduled to be presented to the commission on July 14th. It'll be meeting in this room, and it'll also be broadcast again as this meeting is. The rules will be effective November 1st of this year, 2017, to correspond with the date of the transfer of the regulatory functions here. So until that time, DSHS will be regulating, and then on November 1st is when it changes to TDLR. These rules won't apply to you until we take over the program. You'll still be operating under the DSHS rules. Now, for the mold rules themselves, I want to kind of give you an overview. The TDLR proposed rules for the program are different from the DSHS rules, and there's three main reasons for that. First, changes were necessary to adapt the operation of the program to fit the way that TDLR regulates occupations. Some of these changes result from faster and easier procedures for interacting with TDLR. For example, fees can be paid online. Continuing education certificates don't need to be submitted with every renewal, and department approval of training instructors is no longer required. A second reason that changes were made is to clarify continuing requirements and to remove burdensome ones. For example, employers can now train workers that are employed by other remediation companies, not just their own, and the 10-day notice of cancellation endorsement on insurance policies is no longer required. And the third reason that changes were made was to organize and simplify the rules to make them easier to use and understand. Most of the requirements that are located in the mold statute are no longer repeated in the mold rules. In addition, requirements that are universal for all TDLR programs that are already located in the TDLR statute and rules are not repeated in the mold rules. Examples are the enforcement process and rules related to criminal history. You won't find that in the mold rules. Those are in the universal TDLR rules in Chapter 60. Fees and continuing education requirements are now collected in separate sections in the new rules. y'all are used to one source for the rules. You might have this is the DSHS mold rules. You have to look at 4 sources now. You have the mold rules at TDLR, you have the mold statute, and then you have the TDLR statute and rules. The mold statute's located in the Occupations Code at Chapter 1958, and the TDLR statute is in the Occupations Code at Chapter 51. The new mold rules are in Title 16, Chapter 78 of the Administrative Code. That's what we're looking at today. And TDLR's universal rules are in Chapter 60. So those are both in Title 16 of the Administrative Code, just different chapters. If you go to the proposed rules on the TDLR website, you'll find the TDLR statute and rules in printable documents. So there's links on the side of the web page for Chapter 51 and 60. Those are the TDLR statute and rules. On the website, you can also sign up for the email notices about the mold program if you're not already signed up. The mold statute is on the Texas Secretary of State website, and if House Bill 2007 passes this, or 4007 passes this session, there are going to be some more changes to that statute. It changed when the program was transferred to TDLR, but there are more changes this session in that statute. If they pass, then, as I said, it's going to look different than it does at this point. The mold statute amendments are in Article 11 of HB 4007, and any additional rule changes that are going to be necessary from those statutory changes would be made after the program comes over. The mold statute is not linked on our website yet, but as soon as it's finalized from the changes for this session, then there will be a link on the website. If you go to the Secretary of State's website right now, you'll see all the changes from last session, but you won't see this session's changes because they aren't final yet. It's kind of confusing because it gives you the changes that were made last session and then the parts that are going to be effective when the program moves over in the fall. So, but it's all there as it stands right now before this session. Unlike most of the TDLR programs, the MOLD program doesn't have an advisory committee. Therefore, your input is especially important during the public comment process. So please include in your comments a description of how you and others might be impacted by the changes. And also provide any suggestions for changes in the rules that could alleviate negative impacts. Some changes may not be possible to make depending on the statute and other factors, but if you identify where they're needed, that can help us find other ways to address them. So with that, we welcome your comments on the proposed rules, and as I said, please speak not just for yourself, but for anyone else you feel like is going to be impacted. Because again, we don't have an advisory committee like most of our programs, so we really want your input. Thank you.
Thank you, Laura. I just wanted to kind of reiterate something that Laura said about the different statutes and rules. As the program comes over, there will be a web page for your particular program, and the primary source that you'd look to would be the statute and rules for your program. Then the other legal sources that Laura mentioned, there will be links there for you. So it'll be very accessible for you on our web page, all of those sources of law and rules. So we'll start the public comment process, and I've got I have 3 comment forms, so I'm just going to call you up in the order that I have them, and then just if you'd come on up and please identify yourself. Just say your name, who you represent, if you represent an organization, or if you just represent yourself, and then if you'd please speak into the microphone because we are recording and broadcasting the meeting. So the first person, Monaco O Cunha. welcome. Yeah, you just have a seat, and it would turn the floor over to you, and just anxious to hear what you have to say.
Well, good afternoon. My name is Monique O Cunha. I'm from El Paso, Texas. I work with Sun City Analytical. Sun City Analytical is a licensed training center. We're a consultant agency. We're also a mold lab. We've been open since 1987. We've been doing mold once in a while. We have a little bit of experience on it. And we are comfortable with these rule changes that are coming over. We know you guys have a lot of work ahead of you guys from doing this. I have three basic comments that I would like to make. First one is conflict on the training. You all have stated in 78.25 under continuing education, under B, I'm sorry, under F, 78.25F. I'll give you all a moment to get there. There's a statement there that says that the applicant for renewal of a mold assessment technician may fulfill the continuing education training by either taking a mold assessment technician continuing education course or the mold assessment consultant education course. I don't understand why that statement was put in there in the first place. However, our requirements under a training provider says that we're supposed to give continuing education classes to the same type of class. Therefore, we're saying that now a technician who has less course materials that we would have to teach in an initial class is now going to have to take a refresher class where we'd have to teach them the difference between a consultant and an assessment technician. I don't think that's the right thing to do. We're taking somebody with less education on an initial class and expecting them to take a continuing education class for a course that has more course curriculum in it. I think we need to remove that part and say that if he's a technician, then he should take a technician refresher course or continuing education course. That's my first comment. Second comment is on the continuing education courses. So here we are seeing here that the way I read it is that the licensee is responsible for his own continuing education courses, which is fine. The department has elected to not receive the continuing education courses for renewal of their license, which is fine. As a training provider, however, how or when are we supposed to issue continuing education courses? If the licensee decides to not take his continuing education class within the 2-year license period, does his training lapse? If so, does he have to take an initial class after a certain amount of time? Example, if we issue a course and the course is good for the 2 years that the license is valid, then if his course expires, if his license expires, does his course expires? If so, do we have to do a initial course again? Or how long after the expiration of a course does the licensee have to retake his continuing education class? Tied in with that statement is we have seen that this is the second proposed draft for TDLR. On the first proposed draft, we had a requirement as a training provider to add the expiration date of 2 years from the date they took the course. That's been removed. Therefore, when we issue these course certificates, they don't have an expiration date anymore. I didn't see anywhere in there. And I'd like to see a clarification on that. Does that mean that these courses do expire? Or since we're putting it on the licensee, then they can take the course, move to a different state and say, I got this accredited course under TDLR without an expiration date. Last comment. Actually, I have another thing I'd like to talk about, but my last comment is the course registration. We didn't see anywhere in the TDLR new proposed rules where the training provider would be able to submit or required to submit a training schedule I'm left to think that us as training providers then are now able to register a class whenever we want and hold it whenever we want without the department knowing. Therefore, we can do it whenever we want. I think the problem with that would be there isn't going to be no enforcement on when the classes are given or if they were even valid classes. It doesn't give the department enough time to come out and say, we're going to audit your classes if they so choose to. So I think we need to add that into the regulations here to say that there should be a requirement of submitting when are we going to have the class for the training providers. And that's all on my comments. But I'd also like to add something that Laura, you said, yeah, Laura brought up here, that we do not have an advisory board. Coming from the Texas Department of Health, and we have had, we moved over from asbestos, where we had an advisory board in the past, and we're told that we were no longer allowed to have one, and therefore I don't believe, or I do believe that's why we don't have an advisory board for the mold licensing. I'd like to propose that we add that into the statute. I know here that we recognize there is none at this point, but under section 2110.002, subsection 2, the executive branch allows allows us to have an advisory committee, and I'd like to see if we can push forth on actually having an advisory board committee for the mold regulations. I think there's going to be a lot of comments, and I think we could use that in our industry to have an advisory board established for us. Eliminate requirements for the staff that you have them and the inadequate resources that we may have to actually enforce this agency or enforce this new law. Thank you.
Can I ask you a question
Yes,
about
ma'am.
your first point? Can you clarify, you're saying that you don't think that you should be able to take either one of the courses to qualify for the technician?
I'm sorry, I'll explain it again. So we have two different courses. You have a mold assessment technician, and we have a mold assessment consultant, if you will.
Right.
And so the consultant, in order for us to train them, they have to take a 40-hour course. The technician has to take less hours with less on the curriculum, on the initial course. For the continuing education, we're required to go over these, the course curriculum for a consultant. So if we have the assessment technician allowed to take this consulting class, they didn't take the initial course with all of that. It puts more of a burden on us as a training provider, and I don't know what it does to the technician. I don't know how that benefits the technician, and I don't know how that benefits the department, where then their renewal in 6 years from now is for a technician, and they have a course for the continuing education course for something they didn't take the initial course on. So I think we simplify it by saying, if you're a mold assessment consultant, take a mold assessment consultant continuing education course. If you're a technician, you take a technician continuing education course. There's another law that y'all have in here that says we can't combine the two classes, and that's what it seems that we're doing, is we're taking the technician and the consultant and combining them together in a class, but just giving them the same certificate. So where it comes down to principle, it doesn't make sense. It conflicts, in my opinion, what it says that we're supposed to do as a training provider.
Okay.
Any other questions? Thank you very much. I appreciate your comments. And we just wanted to follow up on one point that you raised, just kind of about the process. There, you talked about an earlier draft, and just to kind of clarify on that, there was an earlier draft of the rules before this version. That was we did some summit meetings around the state for these new programs, and met with kind of had meetings like this where we met with interested folks that showed up for those meetings, and we did present at one of those a draft. There were some changes after that to the version that you see here today, and this is the version that was actually filed and proposed. So just to kind of clarify that. Thank you very much. Appreciate you being here. Okay, Luisa Cunha?
Good
Welcome.
afternoon. Thank you for having me. I really appreciate the time that you give us to be able to put our comments in here.
Sure, thank
I
you.
won't-
If you just say your name,
Okay.
if you would, and who you represent, if
Okay,
you're...
I'm Luisa Cunha. I am one of the owners of Sun City Analytical out of El Paso. And I only have 100 comments. No, just kidding. I have only one comment that I wanted to address. And that is regarding the laboratory. I am a licensed consultant, mold consultant, and asbestos consultant, and I'm also a practicing industrial hygienist with over 35 years of experience. And I am here to plead with you for you to insert just a little word, or, O-R, and that's in section 78.62, item C, 4A1. And a little bit of history. I was involved with the asbestos regulations years back, and I was one of the advisory board members. I also assisted in helping produce the mold regulations. And I was very instrumental in changing a lot of these things within the laboratory, because one of my specialties is the laboratory. We have a licensed laboratory which is accredited by National Institute of Standards and Technology. So we have a lot of QA, QC programs that are in place. So moving over to mold was very simple for me. So I established my mold laboratory. And it calls for accreditation, and this last item, C4A1, allows for our laboratory to exist, which was existing way before Texas Department of Health tried to set up mold regulations. The only thing that I really am concerned with is that it says you have to have a degree in microbiology or biology. I don't have either or. I have a degree in civil engineering, okay? And as such, sometimes I am tasked with going out of town and reading actually mold samples in the field to do the clearance testing. But I have to send a high dollar microbiologist, mycologist to go do that. I can do that. And if you put the word or right after that, that would allow me, that I have years and years of experience reading these samples. I've been doing them before the regulations, like I said, were in place. I know what I'm doing. I also have very high qualified microscopists that can do this. We do need to have some kind of time frame that they've been there working. My employees, the least one that has the least time with me is about 6 years, and they know what to do. Obviously, we have our QA, QC programs that the mycologist looks at. I have 2 PhDs, one out of Reno, Nevada, and my other son who's also a doctor. They all look at all of this stuff. So just by placing that or in there allows individuals like me that don't have a biology degree, but I have a civil engineering degree, to be able to sign off on those results. So that's the only comment that I would like to see.
Can make sure I understand.
Okay.
So there's 1, 2, and 3 under A.
Right.
So this is all individuals who will analyze mold samples have to have these 3 requirements, and you're suggesting the or after 1. So would that mean you either have a bachelor's degree in microbiology or biology, or you have 2 and 3?
Yeah, right.
Or-
You have to have experience and that course, the Macron course or equivalent on learning how to read the samples. So they would still be having a hill of education that they need to have to be able to read these samples. It's not just somebody off the street.
Okay, and I'm just trying to make sure I'm understanding
Uh-huh.
that I'm following your comment there. So,
Mhm.
okay,
That's
appreciate that.
basically, and that's the only comment I have. And I appreciate all the work you guys are putting into it, because I know that it's kind of hard. I've been there, done that. Thank you.
Appreciate your help in this. Okay, well, this is the last comment form that I have, and let's... Sissy, thank you. Okay, Gabe Sissy.
Good afternoon. My name is Gabe Sissy. I'm here on behalf of Mold Inspection Sciences. We are a consulting firm here in Texas, covering the entire state. Specifically, I'd like to address 78.70, Section E, subsection C, as it refers to the consumer mold information sheet. We did notice that coming over from State Health Services, there were some additional regulations added around the consumer mold information sheet, and it could potentially place us into situations where we may lack the ability to follow the regulations. And specifically, what we're asking for is, currently it says that we have to provide the consumer mold information sheet to the client and the property owner or the property owner's designee. There are very few, typically this scenario is not difficult at all, but there are a few scenarios where we don't know who the property owner is, or we'll never have contact with them. So what we would really like to see is perhaps after the owner's designee, a statement placed, if known. A scenario, we are doing an inspection for a tenant in a single-family home that is managed by a property management company, but the tenant is our customer. They may not divulge to us who is managing the property, and we certainly probably will never know who owns the property. Again, rarely is it a scenario that comes up, but sometimes it does. And we would just want to have that out so that we're not in violation of the rules when we have no other option. The second one is, concerns when we provide the consumer mold information sheet to the client or property owner. We're asking for some clarification on these, as these are additional regulations that we haven't had before. It says the first contact with the client, potential clients. So we're asking what is considered first contact. Is it when the client contacts our office and they speak to them on the phone and we book the job? Or is it when the inspector physically arrives onto the property to begin the assessment or the mold-related activity? Which brings me to the second point, is at least one calendar day before. Two scenarios here that would make that hard for us to do. Again, very rarely, but we do have customers that do not use email, typically elderly customers that don't use email, that we have to physically hard mail copies of their reports and everything to. And we also visit residences on the same day frequently. They'll call if we have availability, we'll come on the same day. So, and again, we're just asking for what's the first contact, because that's where we get a little confused with the day before or first contact. The next point concerns the consumer mold information sheet as well, but it refers to a remediation company. So I don't really have any comments for that, but I did want to point out that there are more instances of the consumer mold information sheet discussed, but it refers strictly to remediation companies and not to consulting companies. So I don't have any specific comments for that. But that's what we're asking for, is can we get that small little window on who gets the consumer remote information sheet? And can we get some clarification on what is considered the first contact, so that we can make sure we can set up our rules and regulations for our inspectors appropriately? That's all I have.
Okay,
Thank you very much.
thank you. Is there anybody else that wants to speak today? Those are the only comment forms I had at this time, but we still have some time if anybody has any thoughts that you want to share with us. So. And would you, you don't have to do it right now, but once you're done, would you fill out one of these when you, oh, okay. Okay, thank you. Yes, please. And just, if you would just say your name and who you represent.
Yeah, my name is Tom Luth, L-U-T-H. I've been a mold assessment consultant since we began here in Texas. And one of the things that I have a challenge with is when I do my education renewal, I would like to be able to not hear the same thing over and over every 2 years. I'd like to be able to expand my knowledge and take something maybe in a different state that may broaden my education instead of just repeating the same technical data at each one of the schools. So that's really my main issue, because every time it comes up, I would love to be able to broaden my education instead of taking the same course. And I don't know how. You'd have to have some type of review board that says, yes, this is okay to take this substitute course. That's my concern, is all.
Okay.
What kind of courses are you aware of that, you think would be good ones for you?
Well, there's lots of air quality courses like formaldehyde or sewer gas. I mean, just air quality in general. When we do mold assessment evaluations, we're testing for mold spores in the air or mold spores on the walls or surfaces. And that's a fairly simple process. So to just get the same education over and over again, you're not really broadening your horizons or your education. So I would love it to be able to expand it into other VOCs, for example, volatile organic compounds. And I think that would help all of us in the field become more aware of, for example, smells. A lot of times I'll get calls from clients that they say that I get the smell in my house, I can't figure out what it was, can you come and do a test for this? Well, I have a little bit more broader background because I've been doing this for almost 20 years. But I'm not an industrial hygienist. But you can take sampling for the volatile organic compounds over and beyond the mold, which really helps our clients who call us and ask to figure out what my problem is with my house or my apartment or my building, because people are getting sick. And if we just have a better education for those type of challenges, I think that would really help our industry.
Okay.
That make sense?
Yeah, I think you're saying that you'd be able to rule out other causes and such
Yes.
more easily. And if you had-
Absolutely,
right,
absolutely.
okay,
And if
thank
it's
you.
not mold, what is it? You know, and so there's lots of problems that we have out there. You know, so there's lots of ugly gases and other dangerous volatile organic compounds that we see. And so it's one of those things that would be nice to be able to broaden our education as a substitute in our education.
Thank you. Anyone else want to make a comment? Well, I just want to thank everyone for being here today. If you made a comment or just here to listen, we really appreciate your attendance and being a part of this process with us. We do need your input and help in bringing this program over and making it a success here at TDLR. So let's see. Just want to reiterate, we still have the comment period open, so if there are, if you didn't speak today, but there are other things that you think of or comments that you have, you can definitely get those to us in writing and before May 22nd, and that'll be considered as part of the rulemaking process. So with that, we're going to go ahead and adjourn the hearing. Thanks again for everybody for being here.